Welcome to my channel. My name is Sonia Sims, and on my channel, I make videos about the law. So I talk about advocacy, I talk about criminal litigation, evidence, ethics, anything to do with criminal law, I talk about in my videos. Today, my video is about cross-examination skills, and specifically, I give you 7 tips to help you improve your cross-examination skills. And I was inspired to make this video by Law Venture. Law Venture made a video, I think it was about a year ago, where he talked about cross-examination and he gave his own tips to improve cross-examination skills. And so I was inspired by him to create my own video where I provide my own tips. So I have 7 tips that I'm going to talk about in this video today. I have my notes, and I will be referring to my notes during the course of this, I was going to say cross-examination, during the course of this video. So my first tip is don't be glued to a script. In other words, don't write out your questions verbatim and then simply read them during the course of the cross-examination. This is a common problem when we're first starting out. I've noticed that quite a few inexperienced advocates will have a list of questions that they'll simply read out. And the reason that they have the questions is because they're concerned that during the cross-examination, they'll just go blank and won't be able to formulate a question on the spot. And so I'm going to explain to you why you shouldn't have a script. But before I do that, I just want to do a demonstration.
You stole the money.
No, I made a mistake. No, what had happened was that I was in the pub and this man came up to me and he just gave me the money. He gave it to me as a gift. Okay, so let me explain why having a list of questions is not a good idea. In that demonstration, you may have noticed that the advocate wasn't listening to what the witness, what the defendant was saying in answer to his questions. And the reason why the advocate wasn't listening was because the advocate was glued to the script. The advocate was more interested in trying to see what his next question or her next question, what my next question was going to be, rather than listening to the answer. And if the advocate, if I had listened to the defendant's answer, then I would have realized that there was a huge inconsistency between what the defendant had said previously in court and what the defendant was saying in answer to the question in cross-examination. And so if I had listened properly to that witness, I would have been able to expose the inconsistency, which obviously would have helped my case. So I would advise you very strongly, do not have a script. Another reason why you don't really want to have a list of questions, a script, is because you're not going to pick up on non-verbal cues. So you're not going to be able to see how the witness is reacting to your questions. You're not going to be able to see if the witness is looking nervous, if the witness is looking down, if the witness is fidgeting. They're all signs of the witness being uncomfortable with the questions that you're asking. And if you don't see those questions, if you don't see those responses to those questions, you're not going to be able to probe further. You're not going to be able to dig deeper. And so again, that is another reason why you want to avoid at all costs having a script. So it's really easy for me to tell you what not to do. But what I'm also going to do is tell you what I think you should be doing. So when you are preparing your cross-examination, what I suggest you do is write out your questions in full. So write them all out, type them up on a sheet of paper, write them, and then read the questions to yourself a couple of times. Don't memorize the questions, just read them so that you're familiar with the questions, the way that they're structured, the way that the questions are formulated. And then I would suggest that you throw away the sheet of paper with the questions, and that you have another sheet of paper, and on that sheet of paper, write headings. And the headings will represent the areas that you're going to cross-examine the witness on. And I would write the headings in capital letters, bold font, underlined. And then underneath each heading, I would have bullet points. And the bullet points will be phrases or words, something that will remind you of the questions that you want to ask on each particular area. And that's what I suggest you do. And I also suggest that with your bullet points, the questions, the phrases, not the questions, the phrases or the words are in quite a large font. Because when you're on your feet in court and the pressure is on, suddenly when you look down at your notes, the words will become smaller and smaller. They somehow shrink. Okay, and so I would just make sure that you have large fonts so you don't have to do this when you're trying to see what you've typed or written. Okay, so that's tip number one. My second tip, let me have a look at my bullet points. So the second tip is don't wing it. Don't think that you'll be able to just go into the cross-examination without any preparation and just be able to conduct a devastating cross-examination because you will receive divine inspiration from above. No, it's not going to happen. Preparation is key. Cross-examination is difficult. It takes a lot of work, a lot of preparation. You need to know what your aims and objectives are for each witness that you're going to cross-examine. You need to have worked out in advance where the weaknesses are in the witness's evidence, what you need to probe, and so on and so on. You need to work out how you are going to take the witness to your ultimate conclusion. There's so much to think about in cross-examination. You can't leave it to chance. And I'm going to confess to you that my worst performances in court have been when I've been unprepared. So, preparation, preparation, preparation. And so what you're thinking about is the aims of your cross-examination, the aim for your cross-examination of that particular witness. And I always think that the best way to approach it is to think about, okay, what are the answers that I want that witness to give me? So what are the answers that I want? And then, okay, what questions do I need to ask in order to obtain those answers? Again, it takes a lot of work. Don't leave it to chance. The other thing you really need to think about is my cross-examination of the witness going to be destructive or constructive? So I'm going to talk to you about what I mean by those two terms. So if we think about destructive cross-examination, that's where you're trying to undermine the reliability of the witness. So for example, you might be trying to establish that the witness is lying, that the witness is mistaken, that the witness is biased, that the witness is, what else? Incompetent, okay? So that's destructive cross-examination. You're trying to undermine your opponent's case by demonstrating that the witness is unreliable. The other type of cross-examination is constructive cross-examination. And so that's when you're trying to elicit favorable evidence from the witness. So evidence that will help your case, that will support your case. And some witnesses will be able to give you that evidence. So again, preparation is key for you to identify not just your aims and objectives, but also your approach to the cross-examination of the witness. Are you going to conduct destructive cross-examination or constructive cross-examination? Okay, let's move on. Don't make speeches. Okay, So cross-examination, in cross-examination, you are supposed to put your case to the witness. And I have seen some advocates in the course of putting their case forget that they have to do so by asking questions. And so rather than asking questions, they make this huge speech. Watch. You murdered Mr. Fields in cold blood. You found out that he was having an affair with your wife and you were jealous, frenzied, full of rage. And so you decided that you were going to kill him. You purchased a meat cleaver and you used that meat cleaver to decapitate Mr. Fields. You took his severed head and you cooked it. And you served the head to your wife for dinner, didn't you? You told her it was curried goat. The ultimate revenge for her betrayal. I have no further questions, Your Honour. So obviously that was a huge exaggeration, but I hope you get the point. There was no real questioning of the witness. There was no waiting for the witness to respond to what was put to the witness in cross-examination. So that's not permissible. You have to allow the witness to answer the questions that you're asking, and you actually have to ask a question. So when you're putting your case, don't be tempted to put your case in the form of a long, lengthy speech. Put your case in the form of questions, one bit at a time, okay? 1 point per question. Don't ask one question too many. Quit whilst you're ahead. So you've identified your aims and your objectives with the witness. You know what you want the witness to say. And in the course of your cross-examination, the witness has said exactly what you've wanted them to say. So you'd think that you would quit whilst you were ahead. No, it's happened to me. Instead of just sitting down and waiting for the re-examination or the next witness to be called, I have enjoyed myself so much with the cross-examination. I've got into such a nice rhythm. Question, answer, question, answer. The jury are moving their heads from side to side. Question, answer, question, answer. It's going so well. I'm mastering this cross-examination. What can go wrong? Well, I'll tell you what has happened to me. I've asked that one question too many. And I've undid all of that good work that went before, all because I asked one question too many. So all that good work undone. Quit whilst you're ahead. My next point. Don't demand a yes or no answer. Now, quite often advocates will get frustrated with witnesses who just don't answer the question or don't answer the question in the way that the advocate wants the witness to answer the question. Or the advocate really, really needs the witness to simply say yes or no to the question that the advocate is asking because it's a crucial, crucial point in the advocate's case and just requires a simple yes or no answer. But you can't demand that a witness answer the question yes or no because you're going to alienate your jury. The jury will see you as being aggressive, bullying, and will see your cross-examination as an interrogation. That's not going to go down well with your jury or your tribunal. And so I would advise you not to ask the yes or no question. But if you really have to, if you are desperate to get that yes or no, then rather than demand the yes or no answer, simply tell the witness, or not tell the witness, invite the witness to answer the question with a yes or no. So you have to change your tone and you have to change your words. So invite the witness to answer yes or no. My next point, don't misquote the evidence. Do not misquote the witness. If the witness has given evidence in court and you want to quote what the witness said, make sure you quote the witness accurately. If you misquote the witness, again, you're going to be disliked by the jury. The jury will see you as manipulative and dishonest. Don't do it. Quote the witness accurately. And finally, don't introduce inadmissible evidence. If evidence has been ruled by the judge to be inadmissible, so for example, if the judge has ruled that the defendant's previous convictions should not be admitted in court, so they shouldn't be referred to at all by any of the parties, then for goodness sake, do not refer to the inadmissible evidence, the previous convictions in this case. The consequences could be dire if you do. Well, what could happen? The judge may have to discharge the entire jury, and so there would have to be another trial. And the judge could report the advocate to their professional body. The judge could make a wasted costs order against the advocate. So please, please, please do not introduce inadmissible evidence. So those are my 7 tips. I hope you found this video useful. I'm always looking for topics to create videos about. So if you have any topics that you would like me to cover, anything to do with advocacy, criminal litigation, evidence, or ethics, please drop a comment below this video. Also, please like this video, please share this video, please subscribe and hit the notification bell. It helps the channel to grow. Thank you. Bye.